Yes, now, Mr. Pawanshi.
The points which has already been formulated, I would not trouble your lordships to go again to those properties.
Tell us points wise.
I'll just put and show two decisions. Only to point out to your lordships that how there can be, there has been a reconciliation in judgments of Manjushri, Subhashan, Marva and all. I was pointing it out on the last hearing also, that 2013 judgment of the secret judgment your lordships will find in the compilation. In my notes what I have done is only that I have put the case laws. I given the small facts and what the proposition they hold. So I am not taking to your lordship. I'll just place two decisions. And so far as the facts of this case are concerned, lordship,
Mr. Pawanshi, have you given us written submission?
Lordships we have, but my written submission is not based on proposition. What Mr. Sunil Kumar Jain.
Sunil Kumar.
Yes.
Yes. Lordship may just take a note of that. That is only giving the case laws, what are the facts and the decisions, which is primarily on the fact of indefeasible right, following the Marva line of cases. So those lordship may just keep that because
You'll keep it aside.
We'll keep it aside. I'll just formulate your lordships. And I just show one decision to your lordships in case if it is necessary further, but not
Formulate.
Yes, I wanted to formulate this your lordships, that in a case of a selection, till the stage of preparation of a select list, if there is no change which is happening in terms of preparation of a select list, then there is no question of changing the rules of the game. But for the purpose of appointment, if there is a shortlisting of a candidate, that is what your lordships have put it, then there is no question of the principle of changing the rules of the game being applied. Now that is what your lordships has said in the Yogendra Yadav also, that till the...
Look at your submission.
No, lordship, it's not on the proposition. So...
point, as you're saying.
Yes, your lordship.
Your para 2, you have said.
Yeah.
It is a submission of the petitioner that one principle which has been settled is that mere inclusion of name of a candidate in the select list does not confer on such candidate any vested right to get an order of appointment.
Yes.
And Shankar Sen Das you have quoted, which we saw the other day.
Yes, your lordships. That's the... Then I have put down the judgments, Shankar Sen Das and then Subhashan Marva. I have just put it to the bullet points. And then the decision in JPSC. This was a case where for paper 3, there was no cutoff marks. That's paragraph 5, if your lordship would see. Lordships are looking at my submissions of 13th of
Para 5, yes.
Para 5. This is a case of JPSC. There was no cutoff marks prescribed for paper 3. The cutoff marks was prescribed later of 60%. That was upheld by our lordships. They say that Roman 3, this is not a change brought about, but an additional aspect brought in while determining the merit of the candidate. JPSC case was where 60% cutoff was put for paper 3, there was no cutoff. Lordships have approved it, and the reasoning given was Roman 3, that this is not a change brought about, an additional aspect brought in while determining the merit of the candidate who found fit to be eligible for consideration of appointment as lecturers. Then paragraph 6, I just quoted the judgments.
JPSC may because it's 3 judges.
It's 2 judges, your lordship.
2 judges.
JPSC is a 2-judge judgment. So this kind of inconsistency, lordship will find in.
So, Pawanshi, how do you formulate your, if you can make your submissions 2 or 3 points, give us your best
papers
point.
and just formulate.
Yes. So, lordships, I was not trying to pull out the way the JPSC has done. My submission to your lordships is this, that when till the stage of a preparation of a select list, the criteria which has either been fixed by the advertisement in terms of the rule, till the time there is no change in the preparation of the select list by changing the criteria, the principles of changing the rules of game will not apply. So,
no, come again. I didn't. Why? It will necessarily apply.
No, lordships, I am saying
Select list
till the state
after an advertisement. After that, if it is a prescription of a written examination, it's a written exam. Thereafter, a viva.
Yes.
And after that,
comes
the select list.
Yes. Till the stage of preparation of the select list.
Yes.
The principle of changing the rules of the game will apply. That is what my submission
will apply.
Will apply.
You are saying it will not apply. That's right. Okay,
No,
we'll
it will
apply. We'll apply.
It will
All right.
apply. So like many cases,
You get the
either
point. So, what's the sequitur?
post that, like in what we have seen in Marwa, for the purpose of shortlisting or appointing the candidates, at that stage, there is no question of having an indefeasible right, and where the criteria can be fixed either to select the top or fixing the minimum or a maximum qualifying or a minimum qualifying marks at that
Then the
stage.
question is arising before the select list stage itself.
Right.
As in Manjushri and so on, before the select list,
Lordships.
all of a sudden, without intimation,
Lordships are right.
a cutoff mark is imposed. So
Gotcha.
therefore, the question arises: can that be done or not?
Yes. So my
So that what's your answer?
in terms of the proposition of law, in terms of that principle in Manjushri cannot be said to be incorrect because 25% fixation at the stage of putting a cutoff.
So you are saying that, well, up to the point that a select list is notified,
Yes.
you can't change the rules of the
Yes,
game.
because until that time, because you're not disturbing the merit
He is
list.
right.
Because you are not disturbing the merit list in any manner, because you are following what.
After the select list is prepared, then at the stage of giving appointments,
Yes.
you can say that, all right, I'm going to take the top 5
So
candidates.
like in Marwa, what has been
What's your
done,
point?
the select list has been prepared. Then they said, I'll take 55% and above. Similarly, in the case of Rajasthan, after the selection of prepared select, because that is not
55%.
because there is no disturbance of the inter se merit which has been finally fixed at the stage of select list. That is what my proposition. The one judgment.
The assessment of merit has been made on the basis of the notified criteria.
Yes,
And
sir.
that is the basis of the
That is the
select
basis
list.
of selection.
And once the select list is prepared, then the employer is thinking,
Yes.
I'll take the best 5,
Best of the
or I'll take
Yes,
those who have
Sir.
gone beyond this particular line.
That is what my submission would be.
And the employer is abiding by according to the inter se merit. You're
Inter se
not
merit.
taking somebody lower down and excluding somebody
Yes,
higher
Your
up.
Lordship. At that stage would be my submission as for submitted by at that stage also you still impose a condition to say that you should not still do on an arbitrary basis. That's a different thing that you select 1, 5 and 7 as was suggested, not in that. But in terms of merit, if there is a cutoff being fixed, then there is no question of further questions being asked whether you have done it on some basis or not. That stage should not be there because that was another proposition that should be an exception. Till the time I am not disturbing the merit list, there is no question of me being put to any, as an employee being put to any restriction that I am not
Thank you,
selecting.
Pawan.
So
Last-
only one judgment. This is the broader formulation to your lordships. Rest your lordships are already seen as a proposition. Just one judgment I was trying to cite in the last occasion also.
Which is that judgment?
It's a judgment of just Yogendra Yadav. It said 2013-14 SCC 623. In fact, this is exactly the same.
Small order, obviously.
It says, but it says 2013-14 SCC 623. Paragraph 13 and 14.
What's the principle you are relying?
It's in the compilation volume.
It doesn't matter. We'll pick it up. What's the principle you are relying on?
Paragraph 13 and 14, the same principle which I was suggesting to your lordships.
How do you formulate it? What do they say
Yes.
actually?
They say that what is done in the instant case is that a decision is taken to give appointment only to those persons who have secured 70% marks and above marks in the unreserved category and 65% marks above marks in the reserved category. In the absence of any rule on this aspect in the instant case, this does not amount to changing the rules of the game.
This is Marwa.
Same Marwa.
Same as this is Marwa.
But in this case, your lordships, there was a criteria of 80% marks of 50% marks in the written examination, and there was also a cut of qualifying marks in the interview. After the selection, which has happened, a select list was prepared. Then they again fixed the criteria.
They decided to, therefore, in other words, not select everybody, appoint everybody who was in the select list.
Yes,
But they high and on.
So the Umesh Chand Shukla's principle that after the select list is finally drawn, still you cannot do to 600 is what I am saying should not be treated to be as a correct principle.
All right.
Is my that's a lot.
Thank you. Thank you.
Thank you.
Yes, Mr. Ansaria.
Just on facts, in my case, Rajasthan High Court Lordships has already taken a decision. Since my learned friend was referring to the facts, I'm not taking a terminal Lordships on that because otherwise there will be different. Because Lordships have already taken a decision on that.
Correct.
I'm not.